So we have some amazing news coming out of a federal district court in Illinois. A federal district court judge just struck down the state of Illinois' assault weapons ban and also their magazine ban. So let's talk about this. But real quick, before we jump into this video, I want to thank everybody who's currently supporting the channel. We are rapidly approaching 500,000 subscribers. I just wanted to thank you all and also mention that if you're not currently subscribed to the channel or you're a longtime lurker, please consider subscribing to the channel and help me to reach that 500,000 subscriber goal. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, we have some amazing news, and that is that a federal district court judge in Illinois just struck down the state of Illinois' assault weapons ban and then also their magazine ban. This is breaking news as I'm filming this and reacting to this. We just got the order, so I'm going to read through some of this, kind of give you guys my initial impressions, and then later on, I will probably put out a more comprehensive video, dig deeper into the decision, and also go over some of the broader implications. But I just wanted to bring this to you guys so you have this information, especially if you're in the state of Illinois. So here is the document that we just got. It's in the United States District Court of the Southern District of Illinois. So this is a federal district court. This is the Barnett v. Raoul case and all of the consolidated cases in the state of Illinois against the Illinois assault weapons ban and then also the magazine ban. And it's from District Court Judge McGlynn. Now, I've already scanned this. I can tell you guys that there are some amazing pieces of language in this decision, but ultimately what happens is he's granting a motion for preliminary injunction against the assault weapons ban in the state of Illinois, also against the magazine ban, and therefore temporarily putting a halt on the implementation of this law until the case can be fully developed at trial. So that is what he's doing here. Now, I want to jump to this section right here on page 2, which states on June 23rd, 2022, the United States Supreme Court issued its opinion in New York State Rifle and Pistol Association versus Bruen. Amongst other things, the Bruen court reaffirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive and defensive action in the case of conflict with another person. Less than 2 weeks later, family and friends gathered at Highland Park, Illinois, were enjoying their day, the festivities, and then there was that unfortunate incident that took place. In reaction to that, the state of Illinois then passed the PICA. Then it says, can the senseless crimes of a relative few be so despicable to justify the infringement of the constitutional rights of law-abiding individuals in hopes that such crimes will then be abate or at least not be as horrific? More specifically, can PICA or the PICA be harmonized with the Second Amendment of the United States Constitution and with Bruen? That is the issue before this court. The simple answer at this stage in the proceedings is likely no. The Supreme Court in Bruen and Heller held that citizens have a constitutional right to own and possess firearms and may use them for self-defense. PICA seems to be written in spite of the clear directives in Bruen and Heller, not in conformity with them. Whether well-intentioned, brilliant, or arrogant, no state may enact a law that denies its citizens rights that the Constitution guarantees them. Even legislation that may enjoy the support of a majority of its citizens may fail if it violates the constitutional rights of fellow citizens. For the reasons fully set out below, the overly broad reach of PICA commands that the injunctive relief requested by the plaintiffs be granted. So here you have the federal district court judge saying that this law in Illinois goes beyond what the Second Amendment permits and also runs contrary to the decisions of the Supreme Court in Heller and Bruen. Now I'm going to jump through this document. I'm going to jump to the next section, which is actually the analysis section. But I also need to clarify that to be granted a motion for preliminary injunction, there are two main things that you usually need to show. There is a likelihood of success on the merits, and then also that there is irreparable harm. Usually those are the two elements that a court will focus on to grant or deny a motion for preliminary injunction. And that's what the court is analyzing here. So in the first section, you see them going over irreparable harm. It states that a moving party must demonstrate that he or she will likely suffer irreparable harm absent obtaining preliminary injunctive relief. Harm is irreparable if legal remedies are inadequate to cure it. Inadequate does not mean wholly ineffectual. Rather, the remedy must be seriously deficient as compared to the harm suffered. Assuming aggrendo that there is no presumption of harm for an alleged violation of the Second Amendment, plaintiffs still satisfy this element. For example, Barnett and Norman are no longer able to purchase any firearm attachment, device, magazine, or other item banned by PICA, while Hoods and Pro Gun are now prohibited from selling said any item banned by PICA. These harms are irreparable and in direct violation of the Second Amendment right to bear arms in self-defense. Then they go on to discuss the element of no adequate remedy at law. And again, this is for them to be granted a motion for preliminary injunction. Now, I want to jump down a little bit to the likelihood of success on the merits because really this is kind of the whole ball game. They then go on and talk about some of the Supreme Court cases, the analysis outlined in Heller, and then I also believe the analysis outlined in Bruen. And so as you can see here, they're going Heller, McDonald, and now Bruen, talking about the analysis, talking about how you are supposed to look at these cases in the context of those Supreme Court cases. And ultimately, the analysis is text as informed by relevant history and tradition. And then also under Heller, they talk about common use and outright bans not being permissible on arms that are owned by law-abiding people for lawful purposes. Now, I want to jump down just to the conclusion for those of you who kind of want these short and simple. And here's the conclusion. It states that plaintiffs have satisfied their burden for a preliminary injunction. They have shown irreparable harm with no adequate remedy at law, a reasonable likelihood of success on the merits, that the public interest is in favor of the relief, and that the balance of harm weighs in their favor. So there, the court is saying that they have met all the standards as outlined to be granted a motion for preliminary injunction. Therefore, the plaintiff's motion for preliminary injunction are granted. Defendants are enjoined from enforcing Illinois statutes, and then they outline the statutes here, along with the PICA amended provisions set forth in 735, the Illinois Code 5-25-1, subsection A, including subparagraphs 11, 14, 15, and 16, statewide during the pendency of this litigation until the court can address the merits. The court goes on to say that the court recognizes that the issues with which it is confronted are highly contentious and provoked strong emotions. Again, the court's ruling today is not a final resolution of the merits of the case. Nothing in this order prevents the state from confronting firearm-related violence. There is a wide array of civil and criminal laws that permit the commitment and prosecution of those who use or may use firearms to commit crimes. Law enforcement and prosecutors should take their obligations to enforce these laws seriously. Families and the public at large should report concerning behavior. Judges should exercise their prudent judgment in committing individuals that pose a threat to the public and imposing sentences that punish, not just lightly inconvenience, those guilty of firearms-related crimes. And then it says it is so ordered April 28th, 2023. Now, there's a lot in this decision. Like I said, I just wanted to give a brief kind of announcement to you guys that there was a preliminary injunction granted in Illinois by a federal district court judge here, essentially halting the enforcement of the assault weapons ban, the magazine ban in the state of Illinois, granting the preliminary injunction until the full trial can take place. Now, the state of Illinois is likely going to appeal this, seek circuit court review, and then we'll see how that happens. We will see how fast the state of Illinois responds to this. If they're going to seek something immediate right here and now, a lot of times, like we've seen in the Ninth Circuit, they seek emergency relief and usually get it the same day. So we will see how this plays out. But I wanted to let you guys know that this is currently in place, that we got a huge win by a federal district court in Illinois, striking down the assault weapons ban in Illinois and the magazine ban. The judge here used Bruen, used Heller, and ultimately found that, yes, it is likely that the plaintiffs here are going to win this case because this law goes beyond what the Second Amendment permits. But that's just a quick update of what just happened in the state of Illinois. If I get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.